One decedent took the rare approach of giving gifts just before his death to dispose of some of his property. In re estate of Smith. Alfred Smith died by suicide on May 7th. 2 days earlier, he wrote checks to 4 women. On May 6th, Smith executed a holographic, meaning handwritten, will. Smith's will included a provision stating that he wanted Willard Kressley to have the option to buy Smith's Corvette for $12,000. That day, Smith mailed checks for his sister and niece, along with a suicide note. On the 7th, Smith left checks for his girlfriend and her sister at the women's home. On May 9th, the items Smith mailed were received. All 4 people cashed their checks after they learned Smith had died. Smith's widow asked the 4 to return the funds to the estate. All refused. Smith's widow, who was also the estate's administrator, sued the 4 for conversion. The court addressed the checks and the will's provision about the Corvette. The court held the checks were gifts causa mortis, which means in contemplation of approaching death. With the Corvette, the court held the option to purchase was a request, not an obligation upon Smith's estate. Smith's widow appealed the decision regarding the checks, and Kressley appealed the decision regarding the Corvette. The Pennsylvania Superior Court addressed the appeals.